Good evening, everyone, and welcome to Evening with the High Court Justices. My name is Ryan, and I'm the Vice President of the Public Interest Careers Portfolio at the UNSW Law Society.
And my name is Lauren, and I am the Vice President for Education at the UNSW Law Society. And on behalf of the Society, it is our absolute privilege to welcome each and every one of you to one of the most significant and anticipated evenings on our calendar.
Tonight, we're incredibly grateful to be joined by students, faculty members, including our Dean, Professor Andrew Lynch, members of the legal community, and our exceptional panel, who will be having a wonderful introduction later to, and whose presence here makes this a truly, truly special occasion.
You may have seen the signs around campus reminding us that UNSW is the #1 university in the country, and seeing our panel here, that distinction feels fitting. I think many of us will agree that to have guests of this caliber with us here tonight, all on one stage at UNSW, is a truly extraordinary privilege.
Before we begin, we would like to acknowledge the Aboriginal people as the traditional custodians of the land on which we gather tonight. We recognise that sovereignty was never ceded, and we pay our deepest respect to elders past and present. We also acknowledge the enduring connection of Aboriginal and Torres Strait Islanders peoples to land, water, culture, community, and country.
We would also like to take a moment to thank our stellar team of directors whose hard work has made tonight possible. This evening you will see Julia and Kabir moderating our panel, while Lauren and Rachel will later be making their way around the room, handing around mics if you have any questions to directly ask our very distinguished guests.
It is now our pleasure to formally begin our evening with the High Court Justices. Please join me in giving a warm welcome to Kabir and Julia, who will introduce our very esteemed panel. Thank you.
Welcome students, staff, friends, family, and our honoured guests to the evening with the High Court Justices. My name is Julia, and I'm joined by my co-host, Kabir. The Indigenous people of Australia have inhabited this land for 65,000 years, with discrete systems of law and governance. Only in 1901 was the High Court of Australia established upon the enactment of Australia's federal constitution. The High Court is an apex body of judicial power in the entire country. No court in the country, including the Supreme Court of any state or territory, can make a ruling that is inconsistent with what the High Court has said. If you want to appeal a case, the place to go is the High Court. All of this means that the word of the High Court judge is the law. That law applies to you, to me, and to everyone else in this country. The ones who state the law will sit before us today.
Only 5 days ago, the High Court handed down its latest 4 judgments, which, as we explained, will bind the entire country. One of the 7 justices entrusted with that responsibility is here tonight. Her Honour was appointed in 2022, creating at the time the first female majority in the High Court's history. Before her appointment, Her Honour was a federal court judge from 2008, a justice of the Land and Environment Court in New South Wales from 2006 to 2008, and practicing law since 1991. I'll repeat a famous and often quoted segment from Her Honour's federal court induction. During her time at Sydney Law School, it appears that she, quote, had won every available prize in law. Please join me in welcoming the Honourable Justice Jane Jager. Our second guest is a returning favourite at UNSW, a former High Court Justice who has spent a lifetime championing equality, diversity, and a fairer Australia. He served on the High Court from 1996 to 2009 and was President of the Court of Appeal of New South Wales from 1984 to 1996. Concurrently, the President of the Court of Appeal of Solomon Islands from 1995 to 96. And a federal court judge from 1983 to 84. He has served in international human rights efforts to fight against AIDS, held multiple positions with the United Nations, including investigating human rights abuses in North Korea, and has been awarded 18 honorary doctorates from universities across Australia, Europe, North America, and Asia. He is now more active in his so-called retirement than many are in their careers, as recurring attendees of UNSW events like these will know all too well. Please welcome the Honourable Michael Kirby. And finally, as we've established, being the apex federal court, the High Court's law applies to every state and territory, which means justices of the court can come from anywhere in our country. And no distance is greater in our country than that of west to east. I'm incredibly humbled and grateful to share that our last guest has indeed flown from Perth to Sydney today for our evening with justices tonight. He has served as a judge of the Federal Court of Australia for 22 years, later holding judicial positions in Singapore, Dubai, Hong Kong, and Fiji. He has been a long-time advocate for Indigenous rights, founding the Aboriginal Legal Service in Western Australia in 1973, serving as the president of the National Native Title Tribunal from 1994 to 98, and importantly for tonight's occasion, the Chief Justice of the High Court from 2008 to 2017. Please join me in welcoming none other than the 12th Chief Justice of Australia, the Honourable Robert French.
To remind the audience, Mr. Kirby served from 1996 to 2009, Mr. French from 2009 to 2017, and then 5 years later, Justice Jacob was appointed in 2022 and is serving on the High Court's current bench. That means this panel spans 30 years of the High Court history, almost 25% of it, or a quarter of its total 125-year history since 1901, all in one room in UNSW. We are incredibly grateful to have each of you here. You must be used to hearing this, but it is true. You are an inspiration to us all. With that, I'd like to first ask the justices to introduce themselves to the audience and to let the audience know, who is it that inspires you? It could be a fictional character, a mentor, a family, a friend, or anyone else. I'd like to first hand it over to Justice Jacob.
I have to say, this is going to sound very boring, but I can't identify a particular character, figure, mentor, friend, or anyone else who's a particular inspiration. But what I have come to realise as I got older and progressed, I guess, in life and the law, I am pretty routinely inspired by the people who very actively engage with their world and come to a realisation, probably earlier than I did, I have to say, that you can make a really positive contribution to the world. You don't necessarily need higher education to do it, but we'll come to this later. I think it certainly helps and it gives you an opportunity that you might not otherwise get. And those people who recognise that they can really make a difference to their immediate world, the wider world, and make an effort to engage to achieve that, they're the kind of people who really actively value, I guess, individual human dignity and sort of human consciousness. And we see those people in all sorts of walks of life. Not just in legal life, but in all aspects find those people inspiring, and they are frankly everywhere. So I can't give you one. So I'll hand over. Thank you. Any time short, I'm sure.
Okay, so next, Michael Covey as well. Who is it that inspires you?
Well, I have to say that my parents, if you've got wonderful, loving parents, you get a really good start in life. And you should tell them how grateful you are to them and how much you love them. Anglo-Saxons especially find it very hard to get their lips around love. But it wouldn't be a bad thing if today you ring up, because I have to tell you, when you lose them, you can't bring them, and that's a big loss in your life. As a young lawyer, I became involved in a lot of work at the Council for Civil Liberties. And in that, I learned the advantage of being a joiner. You've got to get out of your own narrow little circle, and you've got to reach out to the world, and you've got to see the injustices that exist in the world, which don't always make their way up to the rarefied atmosphere of the High Court of Australia because of the cost and other impediments. But an example is Owen Westcott. Now, nobody has written a book, nobody knows much about Owen. Owen was the son of a judge who was a very gruff judge, but Owen was a very kind and good man. At about the time that former Chief Justice Spiegelman discovered that the mooring baths were banned to First Nations people, and Chief Justice Spiegelman with Charlie Perkins led a bus up there of university students, and he helped open the mooring baths. Owen got interested in Walgett. Now, Walgett is a town a long way from Sydney, in the middle of New South Wales, in the middle of the desert. But at Walgett, the cinema was divided. First Nations patrons were allowed to go downstairs. That was where everything was lino and vinyl. They were not allowed to go upstairs in the world of velvet and plush seats. It was thought that they were dirty and they had no place being up there. So Owen Westcott organised a group of university students. They went up to Walgett. They rustled up a number of First Nations young people in the town. Owen bought the tickets to go upstairs for everyone, and then the First Nations patrons were revealed. They went up the grand staircase, and the manager rushed out and said to the local boys, "You know the rules, you can't go up there. It's just the same film, you can watch it downstairs, it's all perfectly good, you'll see everything." But Owen said, "We're going upstairs, we want to go upstairs." And so he led them up. The manager called the police arrested Owen and the others. He went to the Council for Civil Liberties. Gordon Samuels, later the Chancellor of this university, now the Governor of this state, accepted a pro bono brief. We went up to Walgett and we argued they had a ticket and therefore they had been given the ticket they could go up. And there was a case about a ferry ticket in New South Wales in the Privy Council in 1900. So we had a good legal argument worked out by the top brains, but the magistrate dismissed the case and he said no, that didn't apply because there was a requirement and they knew the requirement and therefore they're bound by it. That proved how brave Owen was. He could have got a prison sentence for trespass because that's what he was charged with. In fact, he was given a bond. And on the very week that I retired from the High Court, I got a phone call from a person who said, I was the magistrate in that case. You don't know me, but I've seen your career. I want to tell you something. You lost the case, but a week afterwards, the cinema manager changed the policy. So the lesson is, you've got to be a joiner, you've got to get involved, you've got to be concerned with the great moral and other issues of the time, and sometimes you lose the case, but you win the cause. And I think that was something I learned, and I was taught it by Owen Westcott, son of a judge, brave joiner, who worked for people living with HIV, a very good man, and it's the Owen Westcotts and their like who make our cause of law a great moral cause of justice for all, equal justice for all.
Thank you, Mr. Kirby. That was very practical and insightful advice for all of us. And last but not least, Mr. French, who is it that inspires you?
There have been many people I've encountered in my legal career who have had interactions that have stuck in my mind and sometimes changed my life. In the third year of a physics degree, I presented a seminar to my fellow students, as you all had to, on mathematical group theory and elementary particles, which was a cutting-edge topic at the time. 1966. And afterwards, the professor of physics said to me, you express yourself magnificently, but I'm not sure you know what you're talking about. And so encouraged and qualified I enrolled in law. And I met many extraordinary characters in the course of my legal career. Among them was Morris Myers, who was Solicitor General for the Commonwealth back in the 1980s, an extraordinary advocate. I had the privilege of junioring him in Kawata and Gelby Peterson, which was the case concerning the validity of the Race Discrimination Act. And I remember I produced a very comprehensive research brief on the varying attitudes of the High Court towards the external affairs power. And he must have thought I was a little bit overawed by the High Court, for he said to me, they're just chaps, Bob, just chaps. That was before Mary Gordon was appointed. And I saw his advocacy at work in the case for Fencock and Hall, some of you might be familiar with. For those who are familiar with that case, please stick their hands up. None, everyone, yes. It was all about the scope of the corporation's power under the Trade Practices Act, and whether you could validly enact a provision which imposed accessorial liability on individuals who were involved with misleading or deceptive conduct, for example, by a corporation. And I was advancing an argument in favour of the validity of that provision. And I was being taxed by Sir Darrell Wilson, who was a Victorian High Court judge, who kept asking me about the affecting case of an office boy who takes a misleading or deceptive message from the managing director of one company to the managing director of another. And I said, well, this is rather unimaginative. It's not standard response. It's the incidental power. Whether its exercise is harsh or not is a matter for the Parliament. Morris Myers was intervening for the Commonwealth. He adopted our arguments, added some of his own, and at the end of his address said, and as for that wretched office boy who probably hails from Victoria, I have nothing to say. And he was the kind of advocate that could do that. His style was extraordinary. And you remember those sorts of advocates, those sorts of engagements, and there are many of them. And I won't add to the list of war stories, but it's really a mosaic of experiences that generate a particular worldview that you have. And the most important thing, I think, for lawyers and law graduates is that worldview should not be confined to a bubble. And that really reflects on what Michael was just saying.
I once had to give a lecture on it, and it's a really important case. It was the key that unlocked the door that made Marlowe and all the other things that followed possible.
Well, without race discrimination protection, you couldn't protect against state statutory intervention the common law native title. And that was a common law statute which underpinned the constitutional protection for native title, which otherwise, as a common law doctrine, would have been at the mercy of state law.
You've got to jump on the chair, you've got to be noticed, you've got to be there at the time the music stops. And that's how you can end up on the High Court in Australia. You won't get there by just looking after your own pocket. You've got to be willing to do the hard yards, the hard work, the long hours, all weekends. Don't think this is a job for the faint-hearted. This is hard work all your life. And I think that's the most important lesson, but it has to be work motivated by the concern for justice for all.
But there is such thing as work-life balance.
I've not yet found it. I'm going home. If you had only been on time, we would have been able to get away from here and get to our partners. But that's the so-called work-life balance. They can just wait. And that's how it is in life. And I want to get home and have my soup tonight. So we've got to get on with the questions.
Yes, we will get on with it. Alright, let's go straight on to the next thing. Considering such an expansive array of knowledge exists on the panel tonight, we'd like to hear your reflections about the history of Australia's changing values from a high court justice perspective. I'd like to start with you, Justice Kirby, and open the discussion up chronologically as the appointments of the court were made. Although if any justice wants to elaborate on the appointment raised, please have one voice. Mr. Kirby, I've heard you speak on the panel about the respected teacher of yours, Professor Julius Stone. I really like that you dedicated an entire speech just to your mentor. And at UNSW, our teachers are really important to me. I'm actually always counting the enrollment to get the lecture that we want. I mean that sincerely. And for you to talk about Professor Stone, who was our Professor Stone had several ideas that changed Australian law forever, which many of the audience might not be aware of. So I wanted to ask, how did his ideas and teachings influence your career in the High Court and the law as a whole?
It just happens that all of this is in a new book which is just chapter 12, which tells you all about Professor Stone. I do happen, just by chance, to come tonight with some flyers. Julius Stone was the professor of jurisprudence and international law at Sydney Law School, and he was expounding a doctrine of the judicial function which was quite different from the doctrine which was orthodox at that time. That doctrine, which was propounded in a much more complex way that I'm going to describe, as being one of complete and absolute legalism. The law would have lost its meaning if it didn't pre-exist the decision in question. That's what Chief Justice Dixon said. And that was the orthodoxy And that's what all the members of the bar and the obedient members of the courts used to observe, and everybody accepted it. But along comes this professor from Oxford to Auckland to Sydney in the wartime, who came here. He ultimately ended up in the law school at UNSW. All things end up at UNSW. But he was a great teacher, and he picked up some learning from Radbrook, a professor of jurisprudence at Vienna. And Radbrook taught that judges, especially in final courts, have a leeway for choice. A leeway for choice. And so that was what Stone and the Sydney Law School was teaching, and Dixon was propounding quite the opposite. Some people have said, if you want to see the reasons for the Mason Court, why the Mason Court was so different from the courts before, the reason was that the majority of the justices had been students of Professor Stone. And he came to UNSW. He was a very great influence, and you can see his influence later in life in the judges who took over and understood that because values are so important and because our language is so ambiguous, there are going to be choices that have to be made, and the job of the judge is to be faithful to the doctrine and to the principles, but especially in the final court, to be willing to look afresh at some of the old doctrine and to bring it up to date if that is necessary, because they have leeways for choice. And that is the reason of the success of the common law. And that is what I think judges have come to appreciate and to expound in their decisions. And the majority, with different degrees of liberality, have accepted that and practiced it in their work. That seems to have put a bit of Stone was a really great mind. He was a very great mind. He was actually followed around the world by secret references from people who worked with him, who said, well, he's a very great, very considerable mind, but he is very supportive of Israel. You've got to understand this. This is in the 1940s. And that meant a lot of people wouldn't appoint him in Europe. But he got the job at the University of Auckland, and from there he came over to Sydney, and he got the job at Sydney, and his spirit lives at Sydney and in most Australian law schools. And he was a very great influence on me.
Chapter 12 says, or I'm not sure. And on the subject of values, Mr. French, our students, Mr. Cody just mentioned how the Mason Court, one court with a set of judges, there's a certain characteristic to their judgments. And having served as Chief Justice, you're often faced with certain values that we might now consider to be more universal, more Australian values. Reading your judgments and your careers are aligned in a clear sense that one major value between your ideas is an important role in limiting and protecting Australian people from the Parliament infringing upon their rights through legislation. Could you speak to your view on, in general, the changing role of the courts in our country over time?
Well, thanks for that very narrow question. In my legal career, both as focus of my work, and a lot of the focus of the work of the courts, has been in the application, the interpretation and application of statutes. I very rarely have a pure common law problem that doesn't have a statute somehow inserting itself. Even in negligence, you have the Civil Liability Act and sort of a whole array of things. So the interpretation of statutes has become a key feature of the work of all courts. And the interpretation of statutes is a process which involves looking at the text of the statute, the context and its purpose, and then identifying what I call constructional choices. There are very few words in a statute which will offer you one unique meaning. So it is open to the court then to determine which is the meaning that best fits the text, the context, and the context and the purpose of the statute. And in doing that, where a statute impacts upon common law rights and freedoms, the court tends to choose that construction, if it is open, which will minimise the impairment of those rights and freedoms. And given that a lot of the international civil and political rights in the ICCPR are in the nature of customary international law, which can be incorporated in common, we almost have a common law bill of human rights offering an interpretive provision called the principle of legality in much the same way that you have under the statutory human rights acts in Victoria and Queensland and the ACT. And it's really interesting, we say that this is a recent development, that there's been a lot of emphasis on the so-called principle of legality in the last 2 or 3 decades. But it has a long history. It dates back to a judgment on bankruptcy priorities by Chief Justice Marshall of the United States in 1805, where he said, in effect, it's inconceivable that without that the legislature would override common law rights and principles without using the clearest possible language. That found its way into Maxwell statutes in 1904, and in a quote, O'Connor in a case called Potter and Menahan, in the early years of the High Court. It came to prominence in more recent times, when we have a lot of statutory impositions or potential impairments of human rights and freedoms. An example I can give from my own time on the federal court, one of the last cases I sat on before I was appointed as Chief Justice, was Evans in New South Wales. It was World Youth Day in New South Wales. The Pope was visiting. Like the Olympics for Catholics, there were people coming from all over the world. And the New South Wales government passed a thing called World Youth Day, and they passed a regulation, or the Minister made a regulation on the World Youth Day which says that designated officers could direct people to cease annoying pilgrims. Now, there was a bunch called the No to Pope Coalition that wanted to do just that. They wanted to hand out free condoms in protest against the Church's teachings on sexual morality. Anyway, the No to Pope Coalition came to the federal court. I was acting Chief Justice at the time, to challenge the regulation under the implied freedom of political communication. And I sat with Justice Branson and Justice Margaret Stone. And we decided in the end that the regulation should be struck down. We did not have to resort to the implied freedom of political communication. It was just that the regulation making power, we read down by reference to the principle of legality, that it was not intended to go so far as to authorise a regulation which had such a wide-ranging and vague impact on freedom of speech, which is a common law freedom. And I remember using an example in exchange with the Solicitor General from New South Wales at the time. I said, I have attended a Fremantle Dockers football match, at Homebush where they were playing the Sydney Swans. Now, if I am barracking for the Dockers in the middle of a match in the middle of a bunch of Sydney Swan supporters, am I annoying them in the relevant sense? And I was designated after that the Barnard Dockers supporter in the first row. I'm just an episode hopeful. So there are constructional choices, and almost always constructional choices. Those constructional choices can be informed by the Commonwealth principle. And there are more and more of them because parliaments are becoming more and more intrusive. And so that principle becomes more and more important. If I can lead with one final example of a constructional choice, which really doesn't have a lofty human rights principle behind it, it's one of my favourites, and it tells us of the magic of statutory interpretations. Doyle and Maypole's Bakery, a case from the Supreme Court of Tasmania. There was a cake in the front of the cake store in Hobart, Maypole's Bakery, and resting on the top of the cake was a dead blowfly. The local health officers prosecuted the Maypole Bakery for offering for sale an item of food which contained a foreign substance. The question of interpretation was, is a dead blowfly resting on top of the cake contained by the cake? The judge resorted to Alexander Pope's essay on criticism, which has a line in it which says, "So vast a throng the stage could ne'er contain." So if people on top of the stage could be contained on the stage, a dead blowfly on top of the cake could be contained on the cake. There's the magic of statutory interpretation.
You take so long to get to the High Court. Now, you should have been on the High Court a few weeks earlier when I had a case of special leave challenging the appropriation of $50 million which had been made by the federal parliament for the Pope's visit. And I sat with Justice Gummo and Justice Hayden, and those two very great judges refused special leave. I thought it was a fair argument that a provision in the appropriation statute that the Commonwealth could spend money for the good benefit of the people of Australia was too broad and should be read down, and that they shouldn't be using it for a particular religious festival on one religion. And I said we should be granted special leave. I'm still scratching my head as to how I didn't win that argument.
It obviously still rankles, right?
Thank you, Justice French. Mr. French spoke about constructional choices and how the court might read down something at one time, but a different court might not. And that leads to what I would ask Justice Jacob. Your Honour recognised that legal myths are ideas that allow us to subjectively make sense of the world. What influence do you think contemporary values the England court currently have when it comes to revisiting established knowledge in the law, for instance, in the rare occasion of folks making a decision, or otherwise?
The reference to legal myths, it sounds a bit negative. When I spoke about that on another occasion, I was really referring particularly to the notion that's already been talked about that Professor Julius Strain opened up for inquiry, which was the idea that the common law was out there pre-existing and judges discovered the common law, so that when a decision was corrected, it was always the right decision. It was always there. And I was by no means being critical of the idea, because it struck me that it is important to understand the history of the law and why certain ideas of how the common law is developed was seen to be useful at the time, and that it should not just be dismissed as myth in a sort of pejorative sense, but obviously were performing a valuable function, and obviously the functions included were legitimacy of the development of the common law, but also the values that were important in the common law of perceived and actual consistency and perceived and actual continuity of the law. So they were what I had in mind when I was speaking about myths that allow you to make sense of your world. And obviously, as the world changes over many centuries, in which the common law's been involved, and new and different problems and areas of disputes arise, the common law has always managed to respond to those challenges. Apart from that, obviously the bottom line is there is no power or discretion, even if it might appear to be unfettered in the law. I think one of the first things you learn is there is no unfettered at-large power or discretion, and there are always constraints. I think Michael might have been referring to them when he referred to the need to be faithful to doctrine, to be faithful to the principles, and that adherence and the identify the right doctrine, right principles, but two, having done so, to be faithful to those and how they fit within the larger scope of the framework of the law is fundamental. In terms of the interaction of what you call contemporary values with revisiting established knowledge, I mean nothing, of course, I've said none apart. It's always essential to be faithful to that established doctrine and principle. And it appears in so many areas of the law that need for certainty, continuity, consistency, that all sorts of principles that relate to regulate how the common law at least can evolve over time.
I say I don't think there is now much controversy in most judicial circles in Australia about what Stone taught. I think it's now accepted that language can be ambiguous, doctrine can be elusive, and therefore judges do have choices, and their honesty requires them to explain why they chose one rather than another. I think the real new challenge is one that has been presented by the so-called Bangalore principles. The Bangalore principles were from a conference which I attended in India, and one of the attendees was Ruth Bader Ginsburg. And that conference agreed that top judges from all over the world, including Ruth and me, agreed that where there is an ambiguity facing a judge, the judge can, if there is no other source of information that is relevant, reach out to the newly and freshly and quickly developing principles of international law, especially international human rights law. Now, all of this is explained in chapter 20. It's a controversial matter. There are some judges, Justice McHugh, Justice Hayden, and others have denounced it as heresy, but there's a really good article in the latest part of the ALJ. You've got to keep up with all these things, kids. And this is by Justice Baston. He was a professor of the UNSW Law School, and it's about the recent decision of the World Court on climate change and how there is an obligation, rejecting the arguments of Australia in a case before the Royal Court, it says it is a duty of judges to have regard to the Paris platform and to protecting the world, because this is something where international law is speaking and we cannot ignore it, especially because we join these treaties and then we say, oh no, but we don't have a legal statute. So that's the big controversy. I hope I live long enough to see the Vanderbilt principle seeping into the decisions of the courts of Australia, because it's just common sense, as it seems to me, that is the context. Context is always relevant to interpretation, and this is something we should look at and focus on and think about. And Justice Paston's article is a very good one.
I just add a remark on ambiguity. It's a word I don't like much because it suggests some sort of deficiency in language of a statute or otherwise, which is why I have preferred the term constructional choice, that is, that the text offers the court a choice and you apply appropriate principles that which best serves the purpose or which least impairs rights, etc. One case I remember where that kind of question arose involved Justice Ruth Bader Ginsburg. I was her guest at the Supreme Court of the US just for the handing down of the judgment. It wasn't a high-powered constitutional judgment. It was a judgment about a cost statute in which you could recover the cost of an interpreter. The question was it limited to the cost of an interpreter of oral testimony, or did it extend to the translator of a written document? And those of us who observed it, of course, know that translators are far more expensive than interpreters. And they split. They split 6-4, 6-3, I think, and Ruth Ginsburg dissented. The majority took the view that an interpreter in the cost statute was limited to an interpreter of oral testimony and did not cover a translator. There are all sorts of arguments about the general purposes of cost statutes and so forth. But it was a classic example of a constructional choice which had to be addressed by reference to context and so forth. And Justice Alito, a man whom I never suspected of having a sense of humour, read the judgment of the majority, or at least a summary of the judgment of the majority, which said that you could only get an oral testimony, and ended up his summary reading from the bench by saying, and an English language copy of this judgment is available from the registry. If you want to translate it, you have to pay for it yourself.
It's interesting you mentioned that case. I don't know that case, but when I came back from Bangalore, I was the president of the Court of Appeal, and we were sitting in a case where the judge had refused to allow an interpreter to give evidence, the judge in the compensation court. And he was a very good judge, but he said, I have a discretion and I'm not going to do it. And so we got up from our bench, we walked into my chambers, I said, let's have a look at Bangalore, let's have a look at the International Covenant on Civil and Political Rights. Australia has endorsed that, has signed it, and has ratified it. So Justice Samuels and Justice Clark, who were sitting with me, said, yes, let's have a look at that. And when we looked at it, it did provide that a person before a court would have a right of access to an interpreter. And so we went filed back into court, and I had to give the first reasons. And so I said, this is something we can look in the ambiguity of the matter. It's not very much help for the High Court to say, as it had said, that it's in the discretion of the judge. You've got to know what you've got to take into account for the discretion. And so I said we can look at the covenant, and Justice Samuels then gave his reasons, and he agreed, and Justice Clark gave his reasons, and he agreed. That was a wonderful time in my judicial life, Everybody was agreeing, and I wasn't the great dissenter at all.
Thank you all for that very insightful discussion. With that, I'd like to move on to the next theme, education of lawyers and the public. Having learnt about your characterization of the past and present, we are all very interested in knowing how you would approach the future. I'd like to start with the matter of education. I think we all like to be better educated on the world that we live in, but it can be difficult to know where to start. I'd also like to ask questions about education in a sense that captures academic knowledge and broader knowledge of the world. So, Justice Jacob, in your lecture, Burning Bright Without Burning Out, your Honour describes how core features of the legal profession are actually harmful, such as competitive environments in universities and workplaces, long hours, and inequality amongst colleagues. It's clear that lawyers and law students can have blind spots despite their seemingly extensive education. What do you think lawyers should be more educated about?
I think, as I can recollect it, I was identifying that aspects of highly competitive environments can be harmful to people. And I think the message that I was trying to deliver at that time was certainly in terms of I think I was focusing on young lawyers as much as anything that are coming into law practices. And I suppose the thought that I had really is nothing particularly special. It's just that law practices, courts, barristers' chambers, whatever they be, are all workplaces. And that while they may be differently legally regulated, I certainly do have a view that a workplace should not be set up in such a way that it causes people avoidable harm. And also that workplace culture, workplace systems are definitely a sort of top-down type system. So things come from the top and work their way down. I guess my basic message there is I think everybody, each of us in a workplace has a responsibility of basic decency and care towards others. Now, making the point that the law is not for the faint-hearted, and I think in some ways that's true. It is an area where it can, it's definitely challenging. You get used to working hard at law school, and a lot of jobs in the law are can be very taxing. And we don't all have to be superhuman, or to my left, in order to be able to make a real contribution to the law. I'm certainly not suggesting that. I just do think it's very important that an awareness that these are workplaces and that we have fundamental responsibilities of basic decency towards each other in the workplace will go a long way towards ameliorating some of the issues that people, working, especially junior people in the law, who are not particularly empowered and more vulnerable to forms of exploitation. And it's a form of, it's not a deliberate thing necessarily, but certain systems can work towards, the exploitation of young people. And I think we all have an individual responsibility to try to make sure that we do our best to avoid that.
I think this is good. Law is such a fascinating job. We had a case in the High Court, I think it's called Cole against the Twin Peaks RSM greeted tweetheads, and she was hit by a car, and she sued the hotel saying, you owed a duty to me not to be continually plying me with alcohol. And the court divided on it. I think Justice McHugh agreed with me that the majority said, no, she has her own responsibility, she has to look after her own safety, and she can't ignore her safety. And I could see all that. There are arguments against holding the hotel keeper, that if you want to change anything, if you want to prevent somebody who has, say, a drink problem or an addiction to alcohol, they do exist, you know, then you've got to instill in them, both by statute but also by the common law, a state of principle that will render the hotel keeper liable if they don't observe restraint and don't introduce a rule that says, I'm sorry, I don't think you should have any more drink. Some hotels will do it, but the Tweedheads RSL Club didn't, and they got off scot-free, and this woman was injured within a few metres of the pub when she was walking down the main street. So that's why law is so interesting, because there are different points of view, and you've got to go back to your basic principles and try to reach conclusions that fit, as Justice French mentioned, that fits better. And sometimes you can be writing and you can get to a point where it doesn't fit. And then you can be sailing on to a glorious result and you've got to stop and you say, this just doesn't gel.
Thank you both for that insightful discussion, and I'm sure that's some very valuable knowledge that we can bring, especially for those of us who are entering the workplace in a couple of years. So ordinary people don't know much about the law, and it can be difficult for us to make informed choices when participating in our democracy. People especially don't know much about the Australian Constitution or what it actually does. Mr. French, you were critical of the Don't Know, Vote No slogan campaign for the Voices No campaign. The room is keen to learn more about your opinions. Could you speak on civic engagement and education in Australia, especially in the context of constitutional reform?
Yeah, well, we have a real problem with civic education in Australia. And the survey after survey has indicated that at school levels, students are falling short of the national curricular standards in that area. And that can be coupled with increasing degrees of polarisation within Australian society, based upon simplistic understandings of what of the nature of our constitution and the laws made under it. I'm chairman of the Constitution Education Fund Australia, and next month we're convening a conference or a roundtable at Government House in Canberra, hosted by the Governor-General, who's got a particular interest in this area. We're trying to bring together stakeholders, providers in civics education from around the country to talk about how we can better cooperate and develop proposals to improve not just what school children are taught to understand about basic workings, the legal infrastructure, if you like, of our society, but also our wider adult society. At the moment, it's a fragmented landscape, and the what I call the desert of understanding provides room for the snake oil salesman to come in and offer simplistic solutions, and also drive people into what we now see as the silos or the echo chambers of agreement with each other and shouting at everybody who's in another silo. So the basics of civics education is something that we have not adequately addressed, and we have to do something about it pretty urgently. To be a generational issue. Coupled with that is the important value of mutual respect, the ability to disagree respectfully without putting the other side of the argument into some sort of diabolical category that they're sort of subhuman in some way. And we do see a lot of that, especially through social media, which my informal definition of which is an online sewer for the emotionally incompetent and incompetent. And more and more of our population, of course, are getting their basic information through that medium. So there is a lot to be done in this area, and I think the legal profession itself has a role in just contributing to community outreach, to talking to schools, talking to community groups, to people who are not lawyers, not in a condescending or patronising way, but as citizen to citizen. One of my, I did many addresses as Chief Justice of the High Court. My most memorable one was at the end of National Law Week at the Mildura Bowls Club on legal complexity and legal clarity. I was standing up and there were people with hot dogs and kids running around, and I really had to make an effort to cut through. But it was, I thought, a sort of engagement that more of us should be doing more of the time, not just talking to our own professional peers or the academy, but to a much wider community. Michael's done a lot of that, of course. He did a lot of that in his role as President of the Australian Law Reform Commission. But I think that needs to be there needs to be a sense of professional responsibility to contribute to that process. It's a societal-wide process and it's a generational process. But if we don't do something about it, things will only get worse, and we'll slide into a more polarised society with tribes of mutual incomprehension shouting at each other.
Australia could ever get to the state that the United States is in now, one reads in the box that we won't ever get that far because we're not as religious a society, and there is not the influence of extreme religious views that seem to propel a lot of the social media in the United States. And I think it's a question as to whether we have a risk of going down the same track. I hope we haven't.
We shouldn't take our society for granted. And that means we all have a responsibility to make it work. I mean, we've been one of the world's most successful representative democracies. But nothing lasts forever. One of the most troubling results from, I think it was the Edelman Global Survey, which looks at social attitudes around the world, was that there was something like 34% of respondents in Australia thought it was okay to be either aggressive in response to others, right up to a spectrum of actual violence against others. And that was enhanced in the age group from 18 to something or other, I forget what it was. But these are trends of which we need to be aware and which we have to address. So I don't think we should make any assumptions about the directions in which our society might go, especially when you see the pressures of economic inequality, social disadvantage, and incomprehension of how our system works. And that's a problem, particularly for some communities from cultural and linguistically diverse origins, who may come from countries where there's no reason to trust government, there's no reason to trust police, there's no reason to trust public authorities, and who need assistance in understanding how you get access to justice in this country and how it works. One of the things I did after retiring as Chief Justice was to chair a steering committee of the Law Council of Australia's Access to Justice project, which was published in about 2019. That identified 13 categories of disadvantage, and some of them, of course, intersected with each other, and made a large number of recommendations. But what struck me was the incidence which of disadvantage and inequality which can lead to adherence to simplistic or authoritarian solutions. So we shouldn't be complacent about the future future of this country. We are very optimistic about it, of course. I think we've got a great track record, but we need to all engage with making sure that it continues and improves.
Recommended a very significant increase in the funding for public schools. And unfortunately, that has not been delivered. It's not been delivered under coalition governments, it's not been delivered under the Labour Party. And I think unless you tackle this at its root, you're going to continue along the path we're in. We might just copy what the United States and its extremes do. So we should dust off the Dubkowski report, and he should go out and explain why he put forward his view. Public education was one of the great achievements of the Australian colonists. They built it all across the nation. We are the first continent on the planet that had free, secular and compulsory education for all people. We really underline that, and I think that's a very bad thing. Starts in schools. Education starts in schools, and we need to improve the funding of public education.
Thank you, Your Honours. I want to move on now to the topic of how we should approach the future. I want to pose a question to the panel once, and then we will hand the question over to the audience. Each of your honours were at the top of your academics in unique ways. Just as Jay, as we mentioned at the start, has a laundry list of awards from her honours time in law school. Mr. French supposedly has a physics degree, a fellow with a law degree, and Mr. Cody has postgraduate qualifications in law, alongside an economics degree, so a wide variety of knowledge here. What advice do you all have for law students seeking achievements like better academics, or an associateship, or an advocacy or judicial career? And what kind of qualities or habits do you all think are most important in achieving success in these areas?
I think, it always sounds strange, doesn't it, giving advice to people. I do feel very old when not doing this. But if I can encourage people to read widely and not just in law, I would say that every time. Not just non-fiction, not just fiction, but I just think reading widely is the most mind-opening and mind-widening experience that you can have in your life. And then if you go back to what I think we've all touched upon at the beginning, where I identified that I've really come to understand that people, Michael called me a joiner, but I certainly wasn't a joiner as a young person. But what I've come to see is that if you do actively engage with the world, there is such an opportunity for you to make a contribution. And it's easy, I think, as a young person, many people can feel a bit helpless in the face of everything that's going on. It all seems too big, it all seems too hard to make a real contribution. But there is opportunity there. Yes, you can't solve every problem, but you can make a very direct impact on those around you and the wider world in all sorts of ways. And I guess it took me quite a while, personally, to understand that you have to be willing to engage in order to be able to achieve those things. So the other message I give to people that you put it with this sort of wide reading is to some extent or another, many of us can be held back by what I think of as barriers in our own minds about what we're capable of, or things that seem to be beyond us. And we can be quite self-limiting in various ways, whether we recognise that or part of the dual aspect of reading widely, but also making an effort to engage with the world in some positive way. And you can do that in so many different ways, is that it can start to chip away at those sort of self-imposed barriers that you may not even be aware of that are there. Of course, some of them you will be aware of. You might very strongly hold them about how you see yourself in the world. But, you know, these are things that you can recognise them, start to say, okay, well, you know, I should not necessarily have that view of myself or self-limit myself in those ways. The other thing, of course, in life is there are always setbacks in life. Nothing ever goes exactly to plan. Everyone will tell you that. Everybody's experienced setback, everybody's experienced failure in their life in one form or another. And the thing is to not let that be defining of you, but to learn from it. And of course, the other thing I suggest is that take every opportunity you can to write, because the skill of written communication is just of extraordinary value, and that it's a skill, and you can dramatically improve your capacity for written communication by practice. You also do that by of course, reading really good writers. You see how really good writers, and it doesn't have to be law, it can be fiction, but you can see how they can use language to convey a thought or a meaning that's really clear. You can adapt and learn from that how to structure your own thoughts in writing. And to me, writing isn't just conveying a thought. The act of writing itself, like the act of speaking, is thought creation, and clarity of thought is in the act itself. So both orally and in writing, these are skills that you can develop. And the better those skills are, they will serve you throughout your life, whether you choose, whatever you choose, a career in the law or not a career in the law, they're really going to be the best possible service. That's my piece of advice, and hand over to the rest.
I think the first prescription is to be good at what you do. 20 years ago, I heard a sermon on the life of St. Paul at Gray's Inn in London. And the chaplain who gave it was a worldly wise man. He'd been a wine buyer before he went into clergy. And he said at the end of his sermon, what the life of St. Paul teaches us is that God helps the meek and the humble, but also the articulate and the pushy, and particularly the competent. And sometimes there are people who are infused with good social values, a sense of justice, and somehow or other technical competence comes a poor second. You're no good to anybody if you're not good at what you do. Secondly, and this really reflects a theme I think that Jane and Michael have both made, don't live in a bubble. It's too easy to be sequestered within a legal or professional bubble where you talk to each other in the same language, but you're really isolated from the outside world. The third is, and this goes back to the practice of law and what it takes to be a good lawyer, if you're going to be lawyers or a legal professional of any kind, is aim for, you will have pressure to be, and it is the economic imperative of many large firms, for example, that you specialise in particular areas. But it's important to remember that the best specialist is a good generalist. areas of the law that you can isolate from others. I once addressed the Society of Superannuation Lawyers. Now, you'd think that superannuation lawyers might be as narrow a cast as you could imagine. But when you look at it, they have to deal with contract, they have to deal with equity, they have to deal with industrial relations, because it often fits into that category. They have to deal with public administrative law, because there's a regulator, and constitutional law, because there have been constitutions. So there's a whole array of areas of the law that intersect with that. And it's true of so many other areas. So don't be in a specialist bubble. You may be good in a particular area because you're familiar with it, but be aware of the fact that it sits in a universe of legal principles which all interlace with each other. So that's basic, what they call high-level advice, a little immediate practical use, but something to reflect upon.
One of the questions was, in the composite question, how do you get to be appointed an associate? And I would encourage thinking about that, because it's a tremendous opportunity to get inside the decision making and watch it and learn from it. When I came from the Law Reform Commission to the Court of Appeal, there had never been a woman judge in New South Wales. There was one in South Australia, and that was Rona Mitchell, later named Rona Mitchell. And the associates reflected the judiciary, and there were no women associates. I made an attempt when I went to the Court of Appeal, and I appointed a woman associate. She was a Chinese Australian, and she was wonderful, and she knew everything about computers, which at that time was a bit of a mystery. And then a couple of years later, I put an advertisement in the law schools, and one of my colleagues said, "You don't need to do that. They know they've got to write a letter." And I said, "I want to signal that this is going to be an equal opportunity position." And so I got a lot of applications, and eventually I saw a number of applicants in Sydney, and one of them was a woman. And she came forward and she said that she greatly admired my work in the Law Reform Commission and so on, buttered me up. And then she said at the end, when the interview was almost over, "Justice Kirby, I'm very pleased and I'm proud and grateful that you gave me an interview, because I know that you very rarely, if ever, appoint a woman." That was a big shock to me, and it was a rebuke. And she went out, and I thought about it, and I thought, she has a point. And from that moment on, I adopted a principle that I had two associates. One would always be a male, and one would always be a woman. And not everybody did that, but I did it. And a few years later, a woman applied, and she's now the Governor General of Australia. Sam Mostyn. Her forward is in this book. Soon after, I heard what happened to Sarah McMillan. She was the one who said, "You never appoint a woman." And she went into the bar, and she did top cases, the top criminal cases, and she was appointed Director of Public Prosecutions to New South Wales. And she actually had asked me a question, which was a very good cross-examination technique. She went straight for the jugular. She knew she only had a few minutes left in the interview, and she went straight to the jugular of the problem of her getting the job. And She became Director of Public Prosecutions. She's now the judge of the Supreme Court of New South Wales, Sarah McNaughton. So, for those who are thinking of applying to judges, first of all, you've got to put at the end of it, as far as I'm concerned. You didn't really get far if you didn't have good grades. But assuming good grades, what is it going to be that will lift somebody out of good grades into getting the opportunity and the job and so on? And I think you've only got a few minutes to do it. And at the end of the applications, you tend to get what are the most important things, at least for me. What they have joined, what they have done, what they've done for others, what they've done in their spare time, what extra work have they done that is useful to the world and to their society and to the law. So, pay attention to your application. I say to my judicial colleagues in Australia that you should adopt a principle of advertising to make the point that this is equal opportunity, and you should make it an equal opportunity job as far as gender, as far as race, as far as sexuality and other causes. And who knows, your appointee might end up being a federal minister like Andrew Lee, who is one of my associates, or a judge of the Supreme Court, Sarah McNaughton, or the Governor-General of Australia. And that's an important responsibility on the part of the judge appointing, but it's also an important responsibility on your part trying to convey reasons for getting the job, that you've got to make it of interest to the particular judge who you apply to. Those three did that, and they got the job, and they're now in very responsible positions. As many that the ceremony was held in Canberra last week with all the justices of the High Court, and we, the supernumeraries, sitting on the bench at that court for the first time for many, many years. We tend to go to farewells and we go to appointments. We were there, and it was celebrating Sir Anthony Mason, and the court was full, and in the well of the court were many very fine top lawyers who were associates to Sir Anthony Mason. And not everybody can do that, not everybody can become an associate, not everybody wants to. But you've got to be a joiner, in my opinion, and do what you can to have a life outside the law and work just a little bit harder. And if you do that, you might get opportunities. And I hope it happens to all of you, that you all get opportunities that make for the betterment of our country and of the law. Should make this like speed dating, short questions, short answers.
Good evening, my name is Shay Standish. I have a question for Justice Jago. You made a speech back in 2023 on anti-Semitism where you focused on the need for education and for community action to combat anti-Semitism. Do you believe that these actions still hold as the primary way that anti-Semitism can be combated today in the wake of the Bondi shooting and other issues in Australia? Or do do you believe there needs to be an evolution of the law in that regard?
I didn't catch the last bit. Did I need to be, there needed to be,
Does there need to be an evolution of the law in that regard?
I did give a speech. It was on the High Court's website, which does publish the speeches of the judges. It was the occasion, it was the annual Zelman Cowan lecture in the University of Melbourne, and he, of course, a great person and Governor General, former Governor General of Australia, and one of the most important Jewish citizens of this country. And so on that occasion I did give that speech. I think I'm going to echo what both of my colleagues said, the importance of education. I absolutely believe that education, civic education generally, reading broadly, are things that attune people to issues in society. And so I think I said then that education, knowledge of history, I think is absolutely essential to understanding any issue in today's world. You can't just come to the issue as it exists today and expect to be able to, if you're just looking at it as that one day. It's just, there is a context to everything. And so all I can say is I still firmly believe in the value of education in order to bring our attention to many, many issues in society. Thank you.
One more question from the audience.
Thank you, Your Honors. Can I ask, in light of the rapid development of artificial intelligence, I saw commentary saying lots of areas of law practice, such as commercial law, will be largely displaced, whereas some others, such as criminal law, may be less so. Could you provide us some advice as to which specific areas of law we may choose to pursue a career? Thank you.
I'm not sure how it relates to career choice, but there is no doubt that the increasing emphasis on the use of AI in legal practice is replacing what you might call entry-level practitioners. And this is something which is occupying the attention of big firms. One of my sons is a partner in a national law firm. PwC recently made a statement, one of their partners made a statement that those who can't cope with AI will get out, and that they will be replacing lower level, entry-level people with AI. Now the problem there is that many people develop basic skills at entry level, and they build upon those skills as they go further. So the question you have to ask is, to what extent does the use of AI in lieu of humans at the level of these lower level tasks risk de-skilling people? And you can look at much simpler and much earlier examples. How many of us now, how many students coming through can do maths in their head as distinct from using a computer or a calculator with functional operations and numbers without understanding what underlies it? How many can do the square root in their heads? So I think there's a lot of concern about AI and its impact on professional practice. If I can just add by way of digression, development, I'm a representative of the International Science Council on the UNESCO World Commission technology. And one of the things that we are looking at the moment, one of the projects, is the ethical criteria by which you decide whether an output from AI can be treated as knowledge. And this is in the input into the natural and the social sciences. And there are some big ethical questions there. But coming back to your more fundamental question, I think there is a risk of de-skilling. And I would recommend to you a science fiction story published in about 1957 by Isaac Asimov called This Feeling of Power, where Earth was engaged in an interstellar war, where both sides relied entirely upon computers and nobody knew how to do sums in their head, except one man. And then they used him to teach all the pilots. And the last line in the story is where the programmer, chief programmer for Earth, says, 9 times 7 is 63, and I did it in my head without a computer. What a feeling of power it gives you. What power do we lose with AI? So there's a balance between risks and benefits. And I don't know how that affects your professional choice. I don't think you can escape AI the way it's going.
Thank you all for those questions. We will now turn back to our panel.
Could I suggest that in future there should be more time for questions from the audience? It's not only democratic, but it will lead to a greater variety. And I think this business, which I see in a lot of universities, of reading from a script, introduces an element of rigidity, which I think is not a good thing in a university context. That's just a humble suggestion.
It is an honor and privilege to be able to answer questions in this session for analysis. To hear about the High Court, directly from the people who are there, and what we should do in the future. It is nothing less than surreal, truly, and I will alongside you always remember the opportunity forever. Thank you again for the evening.
Just really quickly, on behalf of the UNSW